AM 950, the progressive voice of Minnesota. It's the Matt McNeil Show. The Speak Out Act has been passed, and indeed, this is one of those things where there's definitely going to be a help that's going to come for a lot of people out there with this new rule coming out of Congress. Joining us right now from MJSB Employment Justice is Bree Johnson, a partner over there, to talk about the new rules with the Speak Out Act. Hi, Bree. How are you?
I'm doing well. How are you?
I'm doing well, although I was mentioning to you, you are the first in-studio guest I have had in over 2.5 years.
Yeah, that's wild. It's a pleasure to be here.
I noticed you're comfortably looking around. It's like, really, no one's been in here. Yeah, we've been a little lonely. So usually I'm talking on phones. This is great. It's great. Thanks for stopping on by.
Thank you so much.
How was the good drive? Everything
easy peasy. Yes.
Easy peasy. All right. You, of course, how long have you been with the MJSB?
We formed the law firm a little over a year ago. Collectively, we have much more experience than that. But MJSB Justice is a new law firm as of October 2021. We've got 4 partners. We recently added another attorney.
I was mentioning to you, been passed.
Is a great way to find locally owned restaurants and food purveyors. They feature high-quality food and unique eating experiences for your next meal. Some of those restaurants include Hazel's Northeast Cafe Latte and Scotch Mama's Hot Barbecue. Find a full list of all of our restaurants and food purveyors at eatlocalminnesota.com.
AM 950, the progressive voice of Minnesota. It's the Matt McNeil Show. The Speak Out Act has been passed, and indeed, this is one of those things where there's definitely going to be a help that's going to come for a lot of people out there with this new rule coming out of Congress. Joining us right now from MJSB Employment Justice is Bree Johnson, a partner over there, to talk about the new rules with the Speak Out Act. Hi, Bree. How are you?
I'm doing well. How are you?
I'm doing well, although I was mentioning to you, you are the first in-studio guest I have had in over 2.5 years.
Yeah, that's wild. It's a pleasure to be here.
I noticed you're comfortably looking around. It's like, really, no one's been in here. Yeah, we've been a little lonely. So usually I'm talking on phones. This is great. It's great. Thanks for stopping on by.
Thank you so much.
How was the good drive? Everything
easy peasy. Yes.
Easy peasy. All right. You, of course, how long have you been with the MJSB?
We formed the law firm a little over a year ago. Collectively, we have much more experience than that. But MJSB Justice is a new law firm as of October 2021. We've got 4 partners. We recently added another attorney. We have staff, and so it's been great for us.
What has been your specialty as far as the legal side of what have you been focusing in on?
Yeah, our law firm exclusively represents employees. So discrimination, sexual harassment, whistleblower cases, that's all we do.
And this is why we're having you on here, because there is some big changes that came with the Speak Out Act. Let's first start off by talking what exactly is the Speak Out Act and how long ago did it get passed here?
Well, actually, it's about to go to President Biden's desk. So Congress just passed it last week. Bipartisan support for this, which is pretty remarkable, and we're not talking just a little bit of bipartisan. I mean, I think the House passed it 315 to 109. So pretty widespread support.
I can peg the 109. I'm pretty sure I can. Let me just start writing out names. I bet I get them all. So what was the kind of the purpose of this? Because I mean, it's funny that this is changed because of the former president we had and his insistence that his non-disclosure agreements. And then this is not just for this. I mean, his interpretation of non-disclosure agreements, or at least his lawyer's interpretation, was that even when you were in the White House, you work for the American people, that know that he supersedes everyone else. That whether it is in case of sexual harassment or just employment secrets, whatever the case, so it does not surprise me that Congress at some point said, you know what, we probably need to go revisit this issue and make sure things are a little clearer.
Absolutely. There's been a lot of advocacy in this space, in particular because of the Me Too movement and the way that really came to consciousness to say, okay, you've got Harvey Weinstein, you've got these other actors, and a lot of these people were subjected to NDAs and they couldn't speak. And so the NDA is covered by the Speak Out Act. And the Speak Out Act, what it does is it invalidates any non-disclosure agreement or non-disparagement agreement that you have. And those agreements that are covered by this act are those that are typically signed at the new hire stage. So before any offending conduct has occurred, I sit down, I have a new job, I'm given a packet of information and documents to sign. And typically what's in there is one of those types of agreements. And those NDAs say you can't talk about anything that happens during the course of your employment. And so that's what's covered by and invalidated by this act. And so what I learned through the course of research is over 1/3 of Americans are covered by these agreements. So yes, politics is a big industry where they're covered, but you think about entertainment, Gretchen Carlson is a huge advocate from her experience with an NDA, and she actually broke her NDA to come out publicly to speak about this. And so you have entertainment industry, politics, sports. I learned a lot of athletes, pro athletes or amateur athletes are covered by these. The gymnastics case that came out, a lot of those athletes were covered by NDAs. So it's really big in terms of the impact that this has on people's ability to speak and share about their experiences they're having while they're being subjected to that.
As a non-lawyer, one of the things that you describe here, I mean, I don't think there's anyone, I was talking about Twitter. If you work at Twitter and you're aware of the inner machinations of the computer systems and the stacks and all that works, I have no doubt that because of proprietarial reasons that there is a non-disclosure agreement. You don't just go blab to the next social media company down the road. What feels somewhat nefarious about these NDAs is, as you said, it's the broadness of it. It almost seems like we're hiring you. We know bad things are going to happen here, and we don't care. Sure, we're covering ourselves in regards to company secrets, but we're also putting in basically a preliminary strike to prevent the executive class, the management class, from being held accountable for their unacceptable behavior. I mean, that's kind of, just as a layman here, that's when you look at these NDAs today, before this new legislation came through, it seems like it was a setup to begin with.
Yeah, absolutely. I think that that's a fair assessment of things. And what, is the Speak Out Act covers just the NDAs that are associated with sexual harassment, workplace sexual assault. So just those disputes, they're calling them. It's kind of difficult to describe what a dispute is. I think that's the vague piece of the act, is what is a dispute. But a dispute associated with sexual harassment or workplace sexual assault is covered by the Speak Out, and that's the piece that is invalidated. So any of those tangential arguments about, the proprietary information, the trade secrets, that's all still covered. And so we're just teasing out the pieces that were, like you said, kind of nefarious in terms of isolating a victim or survivor from sharing his or her, typically it's a her experience in the workplace. So you would have a woman, if she has been subjected to sexual harassment and was covered by one of these NDAs, couldn't even tell her friends or family. I mean, the isolation that exists from that, so if someone is brave enough to report and is going through that experience through internal channels at a place of employment, still, under these NDAs, wouldn't be able to talk about it. And that's creates a lot of shame. It creates a lot of isolation. And so it's really good work covered by this.
You understand the law better than I ever will. You understand the wording a lot better than I will. But is it kind of basically, to boil it down to a nutshell, it's like, you can't break the law here. You cannot break the law. You cannot sexually assault someone. You cannot sexually harass someone. You cannot do that. And your NDAs no longer are able to cover those, period.
Yep, that's right. And it's interesting because some of the critics say, well, this is just going to lead to more litigation, because if a company wants to clear their name now, they're going to have to go out and litigate this to be able to, get into the public record in the same way that an employee is. And I think that's, painting a very broad brush and not likely to be an outcome here in terms of the company's exposure. It's just allowing that individual to speak freely. And, in those cases of serial perpetrators at a place of employment, the women or the individuals, if there's several of them who've been harmed, are going to be able to talk about their shared experience. And that's going to hopefully hold the perpetrators more accountable.
Well, and I also think for the people that are the naysayers against this, it's not 1960s. It's not 1970s. There's not a culture of silence. There are a lot of companies that they themselves are no longer tolerant of this kind of behavior. And so it is, I don't think it's going to lead to it. I think there's going to lead to more accountability. And let's face it, that's what I think a lot of the naysayers are really against, is the accountability, being held accountable for your inexcusable actions.
Absolutely.
So,
yep.
All right. So, basically, if you have a non-disclosure, now, first of all, anyone that doesn't have a non-disclosure agreement right now and gets one in the future, after President Biden signs this, done. This is going to be covered, that they can tell you can't talk about the inner workings of the business as far as proprietary, corporate secrets, but necessarily they can't break the law with you. They can't do that. I'm going to ask this question. I know this sounds kind of weird, but are there any NDAs right now where specifically say, by the way, if you are sexually harassed or sexually assaulted in the office, that's part of this NDA? Are those existing? And if they are, does this negate those?
Yeah, great question. And I think that's a line of distinction here. So the Speak Out Act covers only NDAs signed before any of the offending conduct occurs. It does not. So if there's a dispute or allegations of claims and there's a settlement agreement, most settlement agreements are going to have some sort of confidentiality provisions, and the Act doesn't touch those. And so I think that's sort of the maybe. Certainly, there are advocates out there who are advocating that those be invalidated as well. And some states are actually looking into that. But the Speak Out Act does not cover confidentiality agreements, non-disparagement provisions, any NDAs kind of made in the course of settling claims or threatened claims against an employer or individual.
So once again, I think this is an important thing to retouch on here. If you've already been through this and then there's been a settlement, there's no do-over, there's no going back on that. That's set in stone. But if you had a non-disclosure agreement that was in place from the point of this happening, and there hasn't been any kind of agreement or a confident or agreement to drop the case, that this now does apply.
Yeah, before like kind of so long as that NDA was in place before the offending conduct. Yep. Mm-hmm.
Okay.
Yeah.
So then what, it's, I'm going to presume just there's going to be someone, maybe not here in Minnesota, maybe somewhere, someone's going to fight this. I mean, there's going to be a case where it's going to come on down the line. They're going to say, well, this was passed after we did this. And after this, do you feel is they're going to have any success in being able to challenge that?
It's a great question. I mean, I think the perfect attorney response, right, is it depends. There's going to be gray area. I think where a company may come back and say, actually, your NDA was not invalidated by the Speak Out Act, is what we're going to define as a dispute associated with the Speak Out Act. So if I make a complaint through HR channels, for example, is my NDA, does that apply to me? If the HR process says that your HR process is confidential, it's going to get a little bit murky. I think there may be litigation in the future for sure. But at the same time, it's a very unpopular opinion to challenge this, I think, right now. And in fact, what we saw with the Speak Out Act is not many companies were willing to go on the record and kind of voice their opposition to this act because it's not very popular, right? We're 5 years removed from the peak of Me Too, and it's not it's not a very supported position to say we should silence, people who've experienced this conduct in the workplace. I think there's a gaining momentum against that. So, yes, it's possible. I don't think they'll be very successful. And in fact, with as states kind of pick up the mantle and are passing their own laws too, we're seeing more of this momentum in that way as well.
I find it the fact that, and I mentioned Trump, there's one of them. Weinstein, you mentioned Weinstein, and there's another one. And then you also mentioned the United States gymnastics team. What I have it does not surprise me that when you factor all these together, these are worst case scenarios. You only wish this would apply to gun violence. My goodness, heaven forbid. But, what we've got here was, I imagine people that had brought this up in the past would have said something to the effect of, oh, we don't need to take care of this. This is not that bad. So it's one employee, one person. They said, she said, he said, that sort of thing. And now you've had Trump, Weinstein, the U.S. gymnastics. You have these cases where it's a systemic problem that's occurred and has truly traumatized, in some cases, dozens, if not hundreds of people, and as you said, people that can't even really legally even talk to a family member or a friend. I don't even know that they could talk to a counselor, but the reality is the feeling of, this has happened to me. I mean, you look at with the U.S. gymnastics thing, all these victims all pretty much had the same thing. They felt like they were the only one. They felt like they couldn't talk to anyone else. And it was only after this started to unravel that everyone came forward and realized, oh, I'm not alone, that this has really been, this has been something that's been going on for a while. And it's really the worst case scenario, henceforth, not why you have bipartisan support to try to deal with this.
Yeah, I think it's astounding, some of these serial incidents where you saw exactly what you're talking about, 10s to 20, so many survivors coming forward with the same or similar experiences and having no idea as they were experiencing it, or even a few weeks, months, even years removed from it, that there was this collection, this very powerful group had they only been able to speak to one another. And so I think it's absolutely trying to get at that, is that isolation piece. And one of the common defenses for sexual harassment cases in the workplace is, oh, this is a one-off. We had no
Yes.
idea, right?
Yes, exactly.
And there's not a lot of ability to sort of rebut that in a legal process unless you have, knowledge of it happening in another situation. And so if it was covered by an NDA, and now it's not, maybe more information will come that actually this isn't the first time. The employer did have knowledge, or, there were whisperings that this had happened before, and that can be a very powerful motivator.
And we should take a quick moment here. Yes, we have mentioned these really horrific cases, but by all means, if there is anyone out there right now that's in a situation where they're being sexually assaulted, sexually harassed in the workplace, and you got an NDA and it's being held above your head, I'll basically say, first of all, you're not alone. You can fix this problem. And I'll tell people right now, we're going to take a break here, but they should probably call you and talk to you, because you can be an advocate for them to get them out of the situation.
Absolutely. Yeah, I think it's just a really confusing space. In some ways, some of our clients can't tell kind of what's up or down. They just feel like their hands are tied. They don't know what to do. And so by all means, please reach out. That's what we're here for.
Bree Johnson joining us. MJSB Justice is the law firm. We'll take a break. Come on back. We'll talk a little bit more about this, because I think it's also time for us to step back and realize, really, we still have all this much work to do to get equality and equity really in the workplace. Yes, we do. Yes, we do. We have to fix all this. We'll take a break. Come on back. It's the Matt McNeil Show right here on AM 950. AM 950, the progressive voice of Minnesota. It's the Matt McNeil Show. Bree Johnson joining us. MJSB Justice is the law firm. And we were talking about the passing and the soon to be signed into law Speak Out Act, and how it basically, will do a lot to stop the sexual harassment and sexual assaults and sexual, inappropriate behavior in the office. And you talked about the severe or pervasive standard, which is being lifted with this, correct?
I wish.
Oh, you wish. Okay.
Yeah, no. Unfortunately, so in Minnesota, we have the severe or pervasive standard under the Minnesota Human Rights Act for sexual harassment claims.
Okay.
And so that says that's one element of bringing a claim for sexual harassment, is that the conduct must be sufficiently severe or pervasive. And that's a pretty high bar. And so we're talking about, unwanted kissing, unwanted groping. You think of these inappropriate behaviors in the workplace. And often when an employee brings a claim, they have to sort of demonstrate that it was severe or pervasive. And we have one-off instances, for example, that aren't, under the reasonable person standard said to be sufficiently severe or pervasive. It's not enough. And so you really have these survivors having to demonstrate the severity and the pervasiveness of the conduct they experienced. And we have had for many years advocacy to either eliminate this standard or to clarify it. The legislature, I think it stalled out in 2019 was the last pass at it. It might have been 2020. And so it's a real opportunity, I think, especially with what happened in local politics here. There's an opportunity, I think, to revisit this and ideally to eliminate this.
It would seem like what you're describing is a little bit like the drunk driver who tries to just go, well, I'm buzz driving. There's a difference here.
Mm-hmm.
And that's, I think that's a really bad standard, because if you put it out there in an idea that an individual can basically, go up to a certain line and it's not going to be bad enough, that it almost tells them they can go up to that certain line, that there's not going to be consequences under that rule.
Mm-hmm.
So.
Yeah, I think it's a real discouraging effect for an employee who wishes to take a stand and who wishes to, file a claim and try to hold the employer and the individual accountable. And we know that so many victims and survivors choose not to. And this is just yet one more bar that they have to scale across,
Mm-hmm.
and really have to battle those headwinds of that conversation around, yes, it was severe enough, this was awful, and really having to press against this pressure that they have that the other side is telling them it wasn't severe enough, it wasn't pervasive enough. And that's a really brutal experience for someone going through that. And so some employees will drop their claims altogether because of this.
Mm-hmm. This is a good step. The Speak Out Act is a good step.
Mm-hmm.
But clearly, and not just on this issue, it is shockingly disturbing the amount of work we still have to do to make the workplace equitable. And it just in my mind, I mean, it's just like, how is this difficult? And the reality is we have a system that's been put into place that doesn't want to change. And only when it seems like we have these catastrophic incidences where no one can deny them anymore, that okay, fine, then clearly we need to fix this. It's got to be somewhat, it's relieving to get something, and take this step, but the reality is realize how many more steps we have to take.
Mm-hmm. Yeah, that's absolutely right. I mean, this is a really powerful step in the right direction. 5 years in the making, really, in terms of how long people have been advocating, and much, much, much longer than that, really. But it is a bit daunting, the work that's still needed.
Obviously, I want to take the time here. If there is someone who is in the workplace right now that there is, distressing behavior that's happening here, and you don't quite know what to do, may I suggest giving Bree and MJSB Justice a call and at least explaining what's going on, because once again, you're not alone. There are people out there that are wanting to be your advocate and help you out if you're in a bad situation. It just, sometimes you might feel like you don't have any place to go, but they do have the place to call to give you a call, right?
That's right. Absolutely. We'd love to help them out.
What's the number they should call for you?
612-677-2680.
612-677-2680. And even if and once again, I want to make sure we say this. Yes, we talked about these really bad cases, which really were kind of the spur of getting the Speak Out Act passed. But the reality is that it doesn't have to be something where the entire floor is being affected by it. It can just be you, and you need to make sure the individual is being heard here. Not and obviously when it's large groups, of course, but the individual as well. That's got to be make sure that their voice is being heard correct.
Yes, absolutely. That individual deserves to speak up. They deserve to have protection, and really for the perpetrator to be held accountable, and we can help with that.
MJSB Justice. That's MJSB Justice. 612-677-2680 is the phone number. I will link to everything a little bit later on. We'll spotlight this interview. I'll link to everything a little bit later on as well. Bree Johnson, kind enough to join us. Bree, thank you very much. Thanks for coming. My first live guest in forever. This has been great.
Thank you for having me.
I need to clean the studio. Duly noted. Duly noted. I haven't been around too many people lately. I got to fix this. Clean things up. All right, we're going to take a break. Come on back. Thanksgiving week means Terry John Zila is joining us, our food guy. We'll talk Thanksgiving stuff when we do come back. It's the Matt McNeil Show right here on AM 950.